Hola, buenos días. Hoy tenemos nuestra segunda parte de webinars en las cuales vamos revisando todos los países estratégicos donde el mundo de la franquicia tiene mucho que decir, con nuestro socio colaborador Bird&Bird, que es nuestro partner a nivel internacional. Y hoy tenemos la suerte de poder tocar dos países como China y como Australia. Queremos darle la bienvenida tanto a Michael Swin y a Lynne Lweis. Welcome to Spanish Franchise Webinar. Y encantado de que Lourdes, cuando tú quieras, podemos empezar.
Muchas gracias. Sí, como decía Eduardo, muchísimas gracias. Lo primero, bienvenidos a todos y muchas gracias por darnos la oportunidad, la Asociación Nacional de Franquiciadores, por compartir de nuevo una nueva parte de nuestros webinars que tienen por objeto dar unas pinceladas sobre la legislación en distintas jurisdicciones que son especialmente atractivas para nuestros miembros según lo que ellos mismos nos han comunicado. Gracias, Eduardo, y gracias a ti, Verónica, también por hacer esto posible de nuevo. Como ya avisábamos en la invitación, el seminario o webinar va a desarrollarse por completo en inglés, pero no quería dejar pasar la oportunidad hoy de dar unas brevísimas pinceladas sobre cuál va a ser nuestro foco y la importancia de estos webinars para nosotros. Una breve introducción también sobre nuestro despacho para aquellos que no nos conozcáis. Somos en Bird&Bird una firma internacional de abogados con más de 1.300 abogados distribuidos en 29 oficinas en todo el mundo. Además de nuestro ADN internacional, también tenemos un enfoque sectorial y en particular tenemos una gran especialización en el sector de franquicias, contando con más de 50 abogados esparcidos por todas nuestras oficinas. Desde nuestro equipo de franquicia internacional, nuestro enfoque es sobre todo acompañar a nuestros clientes en un crecimiento tanto nacional como internacional mediante estructuras tradicionales de franquicia, licencia o distribución, como con estructuras más sofisticadas, híbridas, más complejas. En ese sentido, y como apuntaba Eduardo, lo que nosotros queremos aquí es daros una breve formación sobre aquellos puntos críticos que tenéis que tener en consideración a la hora de internacionalizar vuestra franquicia, en particular en determinadas jurisdicciones. Quería hacer un breve apunte sobre cómo de complejo es esta toma de decisiones y aquellos elementos fundamentales que tenéis que tener en consideración. En primer lugar, por supuesto, el modelo de negocio. Como ya decía antes, si queréis que vuestra internacionalización sea a través de un modelo de contrato tradicional más sencillo, que tiene sus ventajas, como es el contrato de distribución o de franquicia o de licencia, o si queréis optar por una estrategia más sofisticada que pasa por anudar el elemento accionarial del franquiciado al cumplimiento o incumplimiento del contrato de franquicia, lo cual hace que tengáis un control mucho mayor sobre la red y en particular en los casos de incumplimiento contractual o, por ejemplo, de insolvencia del franquiciado. Por otra parte, es fundamental preparar un contrato modelo que haga que sea internacional, adaptable a cada jurisdicción y localizable en cada jurisdicción para sus particularidades. Y esto conlleva una ventaja que en nuestra experiencia es fundamental para los franquiciadores, que es la posibilidad de que vuestros equipos de negociación internacional sean muy eficientes a la hora de negociar el contrato porque ya lo conocen y, por supuesto, contando con asesores en cada jurisdicción para asegurarnos de que se cumple con la legislación aplicable en cada país. Por otra parte, desde luego, tener en cuenta qué regulaciones específicas son aplicables en cada jurisdicción y cómo de regulado es cada mercado, lo cual van a enfocarse nuestros compañeros a continuación. Por último, la estrategia de salida y la posibilidad de crecer no solamente a través de un contrato de franquicia, sino también a través de adquisiciones estratégicas. Queríamos, por último, llamaros la atención sobre una herramienta que hemos puesto a disposición de nuestros clientes en la página web y cuyo link está en la documentación que posteriormente circularemos, que le hemos llamado International Franchise Laws Tracker y que cuenta con una visión general para muchísimas jurisdicciones, prácticamente todas las que puedan resultar relevantes, sobre la legislación aplicable en cada una de ellas. Y sin más dilación, paso ya al inglés y a presentar a nuestros compañeros. I switch to English now, and we introduce, so I was saying this is the second webinar that we have organized with the National Association of Franchisors, together with our colleagues in different jurisdictions. We have the first one, as you know, was focused in the UK, the Netherlands, and Poland. And this one refers to our two of the biggest markets, which is Australia and China. I introduce here Sven-Michael Werner. Sven-Michael is part of the franchising and corporate team in our Shanghai office and has extensive experience in helping clients structure partnerships with Chinese businesses via franchising, licensing, and distribution. And he will focus, of course, in China. And then Lynne. Lynne is part of our franchise and intellectual property team in our Sydney office and has extensive experience in advising clients on complexities of the franchisee law and the interplay of commercial, consumer, and legal issues. Sven-Michael, the floor is yours.
Thank you, Lourdes. Thank you very much, and good morning, everyone. So we're starting with China, obviously a very, very big market, but it's also a very complex market, not only for legal reasons, but also for business administrative reasons. So it's a very large market, and if it comes to franchising or distribution of goods, imported goods generally, you usually don't have one size fits all for that market. So what we often see is that brands are coming in with multi-channel approaches for the market, and franchising is often one of them. If you look at the advantages, the pros and cons of franchising, as we all know, you can grow very, very quickly. And you can do that without own extensive experience in that particular target market. So obviously this is a big advantage of franchising, and this is a big advantage going into China, because you can potentially expand very quickly in that large country with partners who know that particular location. Because even if you don't do franchising, it's very, very difficult to find one distribution partner who can actually serve the whole of China. So you would deal with different distribution partners, local partners anyway. So that is the advantage of franchising, and that's therefore very suitable. On the other hand, the problem with franchising is obviously often that the level of control, particularly if it comes to quality control, can be low. So you need to have trusted partners. You need to find partners who are familiar with the business models, who have prior experience. And that is sometimes the hard part. That is sometimes the challenge and the hurdle to overcome. So we have advised clients here who started with franchising, because that is the model to expand globally for them in other jurisdictions, but they found it hard to actually translate their business model to others. So we had that, for example, in elderly care businesses, for example, or in sports training businesses, where they thought they have a partner, but then it turned out they don't really understand that particular business and what drives it. So they actually had to take back the franchise, go in by themselves, operate some of the outlets, some of the businesses themselves, and by doing so, bringing in partners to educate them. So I think in reality, franchise is only one way to enter China as a brand or as an owner of a service model. But it's certainly an important one given the size of it. So if we go to the first to the first slide. As so many things in China, also franchising is highly regulated. There are actually only 3 key regulations which contain all these things, but they're quite comprehensive. So we have the general regulations on commercial franchising, which is something like a law, rather vague and general. And then we have implementing measures, in particular for the record filing of commercial franchises, and then also measures for the information disclosure of commercial franchises. Now, what are these regulatory requirements? So if you look at those regulations, you can see some of them already from the title. First of all, we have a record filing requirement in China, meaning that within 15 days of signing that franchise agreement, you need to file that with the Ministry of Commerce of China. Now it says filing, but actually that process is a bit more involved than that, just submitting your documentation. It's actually been reviewed. And because it's been reviewed, the officials at that administrator also have the right and the opportunity to ask questions. And that is often what we see. Unless it is a very straightforward business model, the officials will come back to the filing agents and ask about the particulars of that business model, in particular if they're not very familiar with that. So if you're talking about fast food, it's probably straightforward, but in particular, a lot of more complex service business models, a lot of questions will be asked and answers will be expected. So some of the things the regulators would focus on is, for example, the legality of that model. And the illegality can come from very different areas. We had recently, for example, a particular business model which was quite difficult to explain. And the reason was that it is, in the view of some, quite close to sort of multi-level marketing schemes, so pyramid schemes, Ponzi schemes, which is illegal in China. So we got a lot of questions around that. We had to spend a lot of efforts to explain to the regulators in the context of this filing process that this is actually not a multi-level marketing scheme. It's really a franchise, and therefore it should be registered, it should be filed, and it should be allowed to enter China. So what it says record filing here is actually a quite involved process sometimes, with a lot of back and forth with the regulators. The second one you can see here is information disclosure. So this is the pre-signing information disclosure, and the regulations tell very clearly what information need to be disclosed from the franchisor to the franchisee. And here it's not so uncommon. You know, you have this requirement in a lot of jurisdictions, and the information which is being required there is, in my view, standard. It's quite comparable to most other jurisdictions where you have that requirement. So it's a lot of information on the business model itself. It's a lot of information on the franchisor and his sort of financial viability and health. But it's also information about what else has the franchisor been doing already in the country, in China. So these sort of things would need to be disclosed. And then obviously, if that disclosure has not been done in a proper way, there are the usual consequences of the franchisee having the right to get out again, etc. So this is a civil relationship matter, if you want. There are in the regulations or certain requirements on the franchisor himself. So I'm saying himself, it should be itself because it has to be a company. Other than that, a number of specific requirements. One perhaps stands out. So the requirement is that the trademark, which is part of that license under the franchise, must be owned by the franchisor. And here you often have issues with, you know, the ownership is actually with different entities in the group, and then you have to go and show very much in detail, actually, that these companies are related, are corporate related, are owned under the same group, etc. So these sort of documents, in order to prove that, need to be prepared in advance to be ready really for that conversation, again, in the context of that filing process. So franchisor requirements. And then there are content requirements. So certain clauses must be in the contract and other clauses are not allowed to be in the contract. I'm not going into details, but so the direction of travel here is very clear. The regulation will protect the local franchisee against too unfair contracts coming from the mostly overseas franchisor. So that's the theme here. And then we have, and that is important, we have the so-called 2+2 rule, which means that the franchisor itself, needs to have 2 outlets of that particular business model, which is subject to the franchise, for already 2 years. Now that sounds straightforward, and if you think of the likes of McDonald's, well, that is sort of an easy one. And for a number of companies coming in, yes, it is an easy one. You know, if you're a fashion, then yes, of course, you have hundreds and thousands of outlets somewhere else. It doesn't have to be in China, it can be anywhere. But then you sometimes have businesses who basically have only franchised out from day one. They never run an own business. So they have problems actually showing that this is their own shop, this is their own entity. Then you have sometimes, again, these issues with groups of companies where actually the operations are, that's quite common, that the operations are actually controlled by a sister company or a subsidiary or a more remote company in that group. And then again, you have to show to the regulators in the context of the filing that actually there is this corporate connection between these 2 issues. So the regulations say the license, the franchisor have to have these two stores. But in practice, what is allowed in our experience is that is a directly related company who can have that as well. So but the further that goes away within the group company and sort of the more companies are in between, it's getting more and more difficult actually to get over that hurdle. So that needs to be kept in mind. The sort of the easiest and most straightforward structures are obviously always here the best. But you must fulfill that 2+2, meaning 2 own outlets for 2 years. Yeah, another issue is very briefly, another issue is what is actually an outlet? Again, if you run McDonald's, it's very clear what is an outlet. But we had a client who was organizing certain communities somewhere, and each community was basically one franchisee for certain purposes. And that was very difficult to explain to the regulator that actually, how can a community be an outlet? You know, they expect a store, they expect sort of a physical presence somewhere. And if that business model doesn't really have that, it is very difficult to actually explain that. We managed that then by sort of showing really evidence and proof how that business works, but that can be an issue, really very much depending on how exotic the business model is. Next page, please. Yeah, right. So you see that filing requirement comes with a lot of hurdles, a lot of potential problems. And because of that, a lot of companies have actually chosen to go into China. Franchise companies have chosen to go into China outside of franchise, meaning they have, instead of concluding franchise agreements, they have chosen to conclude typically trademark license agreements plus a distributorship agreement. Well, that comes with the risk, because obviously there is a definition in the regulation, what is a franchise, and it's not a very surprising exotic definition. It is what you would expect. But so a lot of these businesses actually fall under it. And the key is basically franchisor standardized, uniform visual image and business and management model. So indeed, if you just have a trademark license and really just a distributorship, then you can do that, you can adopt that. But if there are these typical franchise elements in that, which gives the franchisor the typical control over the business, up to the limit where you can say, well, the franchisee is just still an independent operator of the business and not the franchisor, then this will be difficult. So in practice, if you want to choose that path because you have issues with how your business is set up to really get through that filing procedure, very likely you will have to make a lot of sort of compromises on what actual rights you will have under your franchise agreement, because you can't really put that into the trademark and distributorship agreements, because otherwise it's still a franchise, because just changing the name of that agreement will just not do it. Next page, please. So what else we have around franchising? So as I said, a highly regulated country. So there are a lot of other things you need to take into account, always depending on the business model, of course, but there are sort of some common themes we see for franchise businesses coming into China. Just picking a few here on this page. Trademark registration is important because the registration of the trademark in China is the prerequisite in order to get a trademark license registered. And also that trademark license needs to be registered with the trademark office, and you only get that if that trademark is actually licensed in China. So, and then you have all these issues. I'm not going into detail about what is actually the trademark. Yes, you have your international English trademark, but probably whatever other language, but probably you need also a Chinese transliteration for that to be recognized here in the market. If you don't do that, if you don't find your own Chinese transliteration for your trademark of your name, of your product or your service, then the market will create one, something which can be written in Chinese characters. And if you have not protected that on your name, someone else can jump into that. So trademark registration is always topic number one, really, when you consider going into China. Data protection, like everywhere around the world, is a very hot topic, a very fast-moving target in China at the moment. We had a number of regulations who contained topics around that, in particular regarding consumers, since 2013, really, and speed picked up since the cybersecurity law in 2017, and now sort of very, very fresh off the press is the personal information protection law. We have exactly 16 days until that law comes into effect, and all businesses really in China, international businesses, local businesses, are rushing to get compliant with that. And that is very much the GDPR of China, if you will. And that has kept us really, really busy helping people getting compliant with that. So data protection, in particular regarding personal information, consumer data, is a very hot topic at the moment. Need to be spent some time on. Yeah, and then sort of obviously more and more business models also in franchising are internet-based. They have internet platforms as part of that model. And then you come into those issues of what do I need from that end? It's highly regulated in China, and there are actually a lot of things in the internet which foreign invested companies or foreign companies cannot do. So if part of that business model is actually it's an internet platform where either your franchisees interact with each other or with you, which we see, or where actually the actual consumers can interact with, then you want to own that and you want to run that platform. But there you're meeting hurdles, because for a lot of these things, you actually need ICP approvals rather than ICP filings, which are off limits for foreign companies. And even if you were establishing a foreign invested or a foreign owned entity here in China, you would not get these ICP approvals. So there the issue is getting into partnerships with local partners who can actually own these approvals and licenses. But how to structure these partnerships again, should that be your franchisee? Probably not. You want to separate that, but that is often an issue which can add quite some complication. And then of course, competition law. There is comprehensive anti-unfair competition law and anti-monopoly law here in China. Also, that needs to be looked at. It's typically not a big problem, because sort of these issues of competition law in distribution chains or supply chains always require a dominant market position. And in sort of the typical franchising markets, we don't really see that very often. So therefore, in China, yes, it is there, competition law is there, but it's not a big issue, typically. Next page, please. Yeah, and so looking a little bit into our crystal ball, what to expect, what comes next, what developments we are seeing here on the ground. Clearly, data protection, I cannot say that enough. That is very fast moving. And yes, we have the law now in what did I say, 16 days, but a lot of sort of details are not clarified yet, in particular if it comes to data transfers outside of China. Very sensitive topic now, even for consumer data. A lot of sort of these procedures are not very clear. What are the exact compliance requirements? So we are waiting to get that clarity from the regulators. So that is something which won't go away. One interesting sort of development we have seen over the years is that regulation from the central government can actually, like this, destroy entire sectors. And sometimes these are also sectors where people have used franchising. So if you look at the education sector, as some of you might have seen, there has been a big crackdown on education businesses, in particular on sort of after-school tutoring businesses, which were, most of them, I would say 85% of them were illegal overnight because the regulation quickly changed. And a lot of these businesses were actually online based, number one, and some of them were actually, you know, coming from overseas. If you think of English tutoring, etc. So suddenly, because of regulation changed, this whole business is not viable anymore. It's just gone. I mean, what to do with that? Well, you can't change that regulation. You can't change politics in this regard. But obviously, you need to think about these scenarios. How likely is it that in your particular industry, for your business model, this happens? You know, how exposed are you? Understanding a little bit the politics and which direction these things are moving in China is important. So education is a good, unfortunately, very unfortunate example where a lot of our clients, a lot of businesses have gone into deep trouble, not only in the after-school tutoring, but actually also in international schools. As you may know, that a lot of international schools are run as effective franchises. And because of high regulation of education, which was not foreseeable 5-10 years ago when these franchises were set up, a lot of these business models are under strain now. So looking at these scenarios when you draft documentation on contracts is a worthwhile exercise to do. Stronger local competition, of course, you have that everywhere, but also here, you know, people look at what international companies are doing here, looking at business models, and if it's successful, you will have very, very quickly 10, 20, 30 competitors. So can you do something legally there? Yes, of course you can, but it's a little bit like wreck them all, right? You can win fights, but you never win the war. So looking at business models, how easy is that to replicate, to copy, to hijack? It's an important consideration as well, more actually from the business side than from the legal side. And that sort of leads us very well to sort of my last point. What actually is not really changing in China is the issues with enforcing contracts, that sort of the formal enforcement processes to get contracts enforced if relationships go south. So there hasn't been any massive improvements in the last years, and we don't expect any there. So what to do? I'm always saying you cannot just rely on your contract. Right, that is a necessity. You have to have the contract, because without the contract, you're doomed anyways. But you need to build a leverage program around your relationship when you're dealing with local partners. What do I mean by leverage program? You're looking at all aspects of the relationship, and you sort of want your partner to be any time during that relationship in a position where, when he's thinking about breaching the contract, he looks at all sort of consequences of that, and he comes to the conclusion it will not be worthwhile. It will be too expensive. And by expensive, I don't mean only monetary, sort of he will be disadvantaged. So just giving you a few examples of what could be part of that. Number one would be due diligence, really understanding who is your partner, what is his business, what are the things he's doing, why he wants to go into this relationship with you, what's in for them. That is key, absolute key to understand, because that gives you leverage. Knowledge gives you leverage. You can play on that. Number two is obviously finance. So payments are important. Who pays first? You know, what sort of money are you holding back? Because that is typically a very, very strong leverage, obviously everywhere in the world, but in particular in China. So money talks, and money puts leverage on other people. So if there is a financial interest to not breach the contract, your partner will rather not do it. And number three is, I mentioned sort of these internet-based business models. That is sometimes a very strong incentive, not just to run away or to pay, because if the business model of that franchise is internet-based or platform-based, the franchisor can always switch it off. And the franchisor often have, you know, consumer and customer data on that. And if you make sure that through these systems, you actually have always access to that, and you can always physically and practically control that, that gives you enormous leverage about franchisees. And we have seen some cases where things went really south, and that was actually basically the trick which sort of, you know, ensured success at the end. So I think that's all from me in a nutshell. Moving on to Australia, I think.
Okay, thank you, Sven-Michael. Just a brief note. that our people listening can ask questions in the chat, right, Verónica? I think we have.
Yeah, that's right.
In Spanish, podéis por favor mandar cualquier pregunta a través del chat y la leeremos al final de las presentaciones.
Sí.
Okay.
Yeah, very happy to answer any questions, whatever comes up. I'm not sure whether I see that on my screen, but
no, I think Verónica will read it for us at the end.
Yes, I will read if there is any questions. I will read it for you.
Yes. Okay, and translate if necessary. So you can post them in Spanish if you prefer, and Verónica will translate for us. Okay, so we go to franchising in Australia. Lynne, it's your turn.
Yes. Wonderful. Good morning, everyone, from Australia, where it's quite dark now. So it's nice to be joining you this morning, your time. It's very interesting to follow Sven-Michael in this presentation, because some parts of franchising in Australia are similar to China, but other parts are very different. Some of the things that were talked about in relation to China that I thought would be interesting to, before we delve into the regulation, to talk about is how the market context is a little bit different in Australia. So Australia is a very large country. For those of you who haven't been here, people often underestimate the geographic spread of Australia. So Australia, to get across from east to west, is exactly the same as traveling across North America, from say New York across to Los Angeles. So it's a very, very big distance across, and again, almost the same distance north to south as well. But in that huge space of land, there's a population of only about 24 million people, and they are predominantly spread around the very perimeter, going from the top on the eastern side down to the bottom on the eastern side, and then a couple of places dotted across, and then a major city at the bottom, and then halfway up the western side, and then very rural the rest of the country, and a lot of desert land that's unpopulated. The reason I raise that is because I think many franchisors, when they first do business with Australia, underestimate what that geography does in terms of the complexity of managing a franchise system in Australia. We're all one country. We are consisting of 5 states and 2 territories. Franchising law and the relevant laws that really affect a franchise business are all the same right around the country, but the geographic nature really impacts what you can do. And what I would say is 90% of the population and the largest cities in the country are on the eastern side of Australia. So when you're based in Europe, you might look at Western Australia and think that it is the closest and the first market to go into. But unless you're going in with a franchise system that really is a system that's going to work very well in a couple of cities that are very much cities that are there for the fly-in, fly-out workers going into the mining industry, Western Australia is not normally the place that's the most profitable to start. If you're really looking for a very good consumer base, starting your franchise on the eastern seaboard of Australia is the best place to start. Many franchisors as well appoint a master franchisee because it is so far away, and they often appoint 2 different master franchisees in Australia. They often appoint one for every state and territory on the eastern seaboard, and then South Australia and Western Australia on the other one. And again, it's because of the geographical diversity of the country. So what I would say in that as well is not only are we a very big country, but we are a very long way away from most other countries. And that means that managing your franchisor or your master franchisee down here can be quite difficult. Our contracts are very much standalone contracts. Our courts are very good for enforcement. That's something that we really differ on from the Chinese experience. But being so far away brings its complexities. So doing your due diligence beforehand, again, is really important in this jurisdiction. And your due diligence there is around the business history of your franchise partner who's going to run the network for you down here, to make sure that they've got a good track record, that they really do have the ability to cover the geographical region that you're giving them and things of that nature, so that when you're on the other side of the world, you know you're going to be dealing with a reliable partner that you're going to be able to control very easily when you need to. So those are the key things that I thought in setting the context. Australia is a very heavily regulated market. The regulation is easy to identify. It fundamentally is in one code, and it's the Franchising Code of Conduct. And like China, it is designed to protect the local franchisee, largely because those local franchisees tend to be small businesses. And our regulations were changed just this year, so effective from July, 1 July 2021, they were changed in several ways that further give protections to the franchisees. So what I'm going to talk about today is just some of the key issues around regulation that come up. I'm not going to go through all of the regulations. I'm just going to go through some of the things that our clients tend to find the most surprising or the key bits of interest when coming to Australia. So we're going to look at very briefly some disclosure requirements, cooling off periods, some notable contract provisions. Like China, the code requires certain provisions to be present in your contract and prohibits certain contract provisions from being in your contract. And we're also going to talk about alternative dispute resolution and the court system here. So if we could go to the next slide, please, Lourdes. Thank you. So the franchising disclosure requirements, we have a set form and you have to present it in that prescribed form. You're not allowed to deviate at all, and failure to present it in that prescribed form and in accordance with the requirements is actually attracts penalties under our law. It's a penalty currently of 66,000 Australian dollars for each infringement. And on top of that as well, it can impact on the enforceability of the contract if you did not give appropriate disclosure before the contract's entered into. Again, just highlighting here that the prescribed form was one of the things that changed when the regulations changed in July this year. So if you've already got a franchise system that's operating in Australia, or you had already started doing your documentation, you really need to be re-looking at that now. You cannot now enter the country with a disclosure document that predated the new regulations. And if you are ready for your annual renewal of your disclosure document, that has to be done by the 1st of November this year. You've got to give the franchise disclosure document together with a number of other documents to the prospective franchisee. That has to be with a copy of the franchise agreement. There's now a key fact sheet, which is, again, in a prescribed form. There's an information statement, which is just a 2-page document that gives some key information to the franchisee. Plus, you've got to give a copy of the code. Also, if you're requiring the franchisee to sign a lease that you've already negotiated, for example, you've got to give a copy of that or any other document that you've negotiated on their behalf that they have to sign. When do you have to do this? This, again, is something that has recently changed. You now have to, sorry, that's not what's recently changed. It's the next point that's recently changed. 14 days before entering into the franchise agreement or accepting any non-refundable payment, whichever one of those is the earlier, 14 days before that, you've got to give the franchise disclosure document. The new aspect I was about to refer to is on transfer of a franchise. If your franchisee, whether it's a master franchisee or a sub-franchisee, is proposing to transfer their franchise agreement and they come to you and request consent, you now have to give the incoming potential franchisee a disclosure document. And again, that's got to be 14 days before you either enter into a new agreement with them, if you're going to be signing a separate newly negotiated agreement. Or if it's simply transferring the same agreement, it's got to be 14 days before you give consent to the transfer of that. As I mentioned before, it's also got to be updated once a year. Now, the exception to that is if you are a master franchisor and you only have the one master franchise agreement coming into the country, and then everything else is done by your master franchisee, you don't have to update every year. But if you have more than one agreement, you do. If we could go to the next slide, please, Lourdes. Some notable provisions. There's a cooling off period. So in addition to having the disclosure before the agreement is signed or money is taken, even after the agreement is signed, there is now a mandatory cooling off period of 14 days. And that is a one-way cooling off period. The franchisee can terminate in that 14 days and they can walk away from the relationship. That is not there for the franchisor. Secondly, there are provisions around circumstances in which a franchisor can terminate a franchise agreement. This is one of the things that most people find surprising about our regulation here in Australia. There is very limited grounds on which you can immediately terminate a franchisee. In the vast majority of situations, you have to give notice to the franchisee, telling them what they need to do and allowing them a reasonable time to cure the fault. Now, if they cure the default, then you can't terminate them for it. Now, lots of my clients want to put in a provision that says if you've breached twice or 3 times, that then we can terminate you immediately. Unfortunately, that is not allowed under Australian law. So there's very few circumstances you can terminate immediately. Under some regulations that changed this year as well, even when you're allowed to terminate immediately, you still have to give 7 days notice so that the franchisee can go and seek redress either in the court or through a mediation if they think the termination is unlawful. The reason why that provision was put in there is because otherwise what was happening was that franchisors were terminating franchisees, and then it was too hard for the franchisees to get their business back if the termination was found to be unlawful, because too much water had passed under the bridge by that point. So 7 days, but you can stop them operating the business during that period of time. You just can't fully terminate their agreement. Then there are provisions now, again, new provisions that relate to termination by the franchisee. The franchisee, other than in the cooling off period, does not have any absolute right to terminate the franchise agreement unless you have agreed to that contractually. However, under our law, if a franchisee comes to you with a proposal where they want to terminate the franchise agreement, you as the franchisor now have to consider that proposal and respond to it. And if you are choosing not to terminate in accordance with what the franchisee has asked for in the proposal, you have to spell out the reasons why you won't terminate in accordance with that proposal. And anytime the franchisee comes to you, you have to go through that same process. So you can get multiple requests like that, where the franchisee might be trying to talk you into it. As I say, you don't have to agree to it, but you do have to respond and give your reasons each time. Restraints of trade are always interesting concepts under Australian law. Our courts do not like restraints of trade. They see them as anti-competitive and against the public interest, but they do uphold them if they are reasonable in the circumstances. It's got to be reasonable in terms of both the geographic nature of it, the time period of it, and also what you're actually restraining the person from doing. But importantly, on top of that, our franchising code says that if a franchisor terminates a franchisee and the breach that they are terminated for is not a serious breach, then the restraint of trade cannot be enforced against the franchisee. They should be allowed and are allowed under our law to go ahead unrestrained and start another business. It's only if they were in serious breach that you can enforce the restraint of trade against them. That is a brand new provision under our law and is yet to be tested to see how that actually plays out and what will amount to a serious breach. The other thing I wanted to comment on there is releases. Franchise agreements most often contain in them a release by the franchisee of, which is like a general release of claims against the franchisor, or for example, when you're agreeing to a transfer of a franchise, franchisors often want to put into the agreement that there will be a release of all claims by the outgoing franchisee in favour of the franchisor. That is prohibited under Australian law. You cannot require or request a franchisee to sign a general release in your favour. Secondly, a franchise agreement is not allowed to have a clause in it that contains a waiver or a release from any prior representations, whether they be oral or written, before the franchise agreement was entered into. So you cannot have a clause that basically says, this is our agreement and nothing we said before it is of any effect. The final thing I wanted to comment on in this respect is the statutory consumer guarantees. This is a separate piece of legislation that comes under our competition law legislation in Australia. And those are the guarantees that are given to consumers in relation to the quality of products, that they're of acceptable quality, that they're fit for purpose, etc. Those consumer guarantees apply to consumer goods or services, irrespective of whether they're just directly supplied to a consumer or if they are supplied in a business-to-business relationship. The threshold is a monetary threshold. If the good or service that is being supplied is supplied at a value of less than 100,000 Australian dollars, then the consumer guarantees apply. Now, I'm not going to go into a whole lesson on the consumer guarantees because that is a very long and complex discussion, but it is very important to know that there are guarantees that do apply in relation to the goods or services that often a head franchisor is supplying in a franchise relationship, and you cannot at all contract out of those consumer guarantees. They are mandatory, and it is illegal to try and contract out of them. The final point I wanted to talk about is dispute resolution. I think there would not be a single franchise system in the world that hasn't had a dispute at one point or another. We all know that that is something that is very difficult to deal with, particularly with the small businesses who might be your franchisees. In Australia, under the Franchising Code, it is compulsory to have a specific alternative dispute resolution clause included in your franchise agreement. That clause has to be used included in the words that are included in the code, and it provides for either mediation or conciliation. Either party to a franchise agreement who thinks they have a dispute can elect to put that dispute through the alternative dispute resolution mechanism. If one party elects to do that, the other party is compelled to attend and seek to resolve the dispute in good faith. Now, that does not mean that you have to resolve the dispute at all costs. You've just got to try in good faith. Good faith involves a commercial reality to it, so you don't have to just give in, but you've got to try, and you do have to attend. Attendance can be by video, for example, but if you don't attend, again, there are penalty provisions of 66,000 Australian dollars for failure to attend. The code also provides for arbitration. You do not have to include an arbitration clause in your franchise agreement, but there is an arbitration provision included in the code, and a party can elect, even if the clause is not in the agreement, to put a dispute through arbitration. And if the other party does that, you have to go to arbitration. Two final points I wanted to mention. One is jurisdiction. Where do you have to do your mediation or your arbitration? And which court can you go to if you need to seek court assistance in a matter? Under our law, it has to take place in Australia. Your agreement cannot provide and require a party to go through a dispute resolution mechanism or to a court that involves outside of Australia. Your governing law can be the law of another jurisdiction, but it still has to be dealt with here physically in Australia. And even within Australia, if, for example, your franchisee who you've got a dispute with is based in Queensland, then your agreement has to provide for it to take place in Queensland. It can't be in New South Wales, for example. The last point I wanted to mention is one that is a very hot topic in Australia at the moment. Under our new regulations, you can have multi-party disputes. There are often many instances in a large franchise network where a number of different franchisees will have a similar dispute with the same franchisor. In the past in Australia, franchisors used to require the franchisees to deal with those disputes one-on-one, separate disputes. If I have a dispute with X, that's a dispute between me and X. Dispute between me and Y is a separate dispute that has to be dealt with separately. And as a franchisor, I never wanted them put together. I didn't want them sharing information. And I made sure they kept everything confidential and abided by their confidentiality agreements. Under our new regulations, the franchisees can join together and bring their complaints and their disputes, whether through mediation, arbitration, or the courts, all as one or in little groups if they want to. And you cannot enforce a confidentiality obligation between them. They are allowed to share freely amongst them for the purpose of the dispute, the information that is relevant to them and their dispute with you. You can't stop them talking together about anything. Now, that is something that many franchisors are very nervous about, because in disputes, you often don't want people talking to each other. And time will tell as to whether or not that truly is an issue, or whether people were talking to each other and helping each other anyway. But in summary, Australia, I think, has a high bar to reach in terms of your initial setup to come into the country to get your documents compliant. But once you're here, it is actually a very good jurisdiction to work in. It's a jurisdiction where your contract means what it says on the paper. It's a jurisdiction where your courts are there here in Australia and able to help you. And it is a very user-friendly court system compared to many other countries. I'll leave it there, Lourdes, for any questions.
Thank you, Lynne. Okay, I think very interesting speeches. Let me just, point out how, as in the other webinar, we saw there are multiple similarities when going into the different countries, like regulations that look alike or may seem to be alike, but then big differences in relation, for example, to what happens in Spain, very different in relation to content requirements, which are not which we're not familiar in Spain, because it's not regulated to that extent. But of course, we are familiar with the disclosure requirements and other types of things that apply almost across the world, I would say, with, of course, big differences. And I think very, very interesting speeches. Thank you both. And Verónica, no sé si hay preguntas.
Lourdes,
sí.
Perdona, que yo quería hacer, haz la traducción porque me parece muy importante y no quiero perder. que el ponente entienda perfectamente la pregunta. Tengo una para Sven-Michael en China, que es, en primer lugar, ¿cuál es el nivel de seguridad jurídica que con el registro de marcas es tan importante en el mundo de la franquicia? Eso es un tema que en España preocupa, primer punto. Y luego para Lynne, en Australia, quería preguntarle la relación entre franquiciador y franquiciado. Incluso hay alguna sentencia en Australia que ha decidido o ha sentenciado que el personal del franquiciado es miembro del franquiciador, con lo cual, lógicamente, esto es una grave preocupación, sobre todo en Europa y sobre todo en España, ¿no? Por lo que pudiera significar. Gracias de antemano, y creo que son dos preguntas que las tenía guardadas para el final porque creo que son, para mí, francamente importantes.
Muy relevante. Now let me translate. Eduardo has two questions, one for you, Sven-Michael, and another one for you, Lynne. So the first one in relation to China is, in your opinion, what is the level of legal security or legal safety environment in relation in particular to the register of trademarks? That is something that worry a lot. This is a very sort of a high concern for our franchisors here in Spain.
Yeah, thank you for that question. I think trademark protection is one of those areas in China which are very developed, very advanced, also if it comes to enforcement of rights, so relatively safe. Once you have a trademark registered, then you'll be able to enforce that through the typical channels, and that all looks very, very similar, like, for example, in the European Union. The issue is sometimes that the approach of Chinese regulators, but also courts, is very formalistic. So people don't really look so much at sort of the substance of the issue of that particular dispute, for example, but purely only on the process and the formalistic requirements of something. So sometimes you end up in cases where it's very, very clear, there's the bad guy and what he's doing, and sort of under the normal jurisdictions, you would say it's very, very clear, what happens, and it's very, very clear how a certain dispute should end up, because obviously there's always a certain degree of discretion in every case for the decision maker. But in China, it would not happen. Sometimes, yes, it is sort of local protectionism if you're dealing with very local places and provinces. But it's often just the approach to law. It's very formalistic. So this you need to keep in mind. So once you have a good case and you go, in particular in trademarks, you go to regulators or to courts with that, you can win, absolutely. And I'm not a trademark lawyer, but my colleagues here, they do that all the time. Does that mean you sort of, what I said, does that mean you win that war and you're getting at the end of the day what you want? No, because often then the problems lie in the execution and enforcement of that. And then you have to go into, which company is it actually? Where do I find them? And all these sort of things can be really difficult at the end of the day to win. So the situation is not perfect, but if it comes to sort of formal procedures, and if you have a strong case with strong evidence, definitely you can win.
Thank you, sir.
Thank you. Then the question for you, Lynne, is in respect of the relationship between the franchisor and the franchisee. We understand there has been court rulings whereby in Australia, whereby it seems that the franchisee's employees would be considered the franchisors, and so to some extent the independency between both parties' businesses has not been respected. I don't know if you have that experience or you can throw a little bit of light on that.
Yes, I can. The starting position is that usually you are not responsible as franchisor for the employees of the franchisee. However, there has been some cases in Australia where franchisors have become responsible And the circumstances in which that has occurred has been in large franchise systems where the franchisees were underpaying their employees. We have minimum wage requirements in Australia, and we have occupational health and safety requirements in Australia. And there were a number of very large franchise systems, 7-Eleven was one of them, where franchisees were not paying in accordance with the minimum wage. And they ultimately claimed that the reason they weren't paying in accordance with minimum wage was because the requirements put on them by the franchisor were so onerous that they could not afford at all to be able to pay the employees. There would have been massive losses, and so it was impossible for them to do it. And the franchisors in those circumstances were aware of the facts. That meant that it was found to be a situation where the franchisors should have known, even though they might not have known the specific circumstances of particular employees being underpaid, they would have had enough knowledge to know that the franchisees could not possibly be paying minimum wage in order to be operating their businesses. And so that is the circumstance where it has opened up a level of vicarious liability for the acts of the franchisee, but it is quite limited. The additional thing I will say there is 7-Eleven was one of the companies involved in that. 7-Eleven has just had a class action against it brought by franchisees. That class action has a provisional settlement in place at the moment. It's a settlement that has been agreed between the parties and now needs to be sanctioned by the court as being appropriate. That settlement is for 98 million Australian dollars, and it is due to be looked at by the courts in the first week of November. But we expect that the court will uphold that that's an appropriate amount of money to be paid by 7-Eleven to the individual franchisees who alleged that they were misled and that there were other contractual breaches in relation to their franchise agreements. It was this whole issue around a couple of very large franchise systems, predominantly starting from the underpayment of employees, that led to a massive inquiry, a parliamentary inquiry here in Australia that lasted for 2 years into franchise systems. And that led to the new laws that we had brought in that became effective on 1 July. So you are very correct about that issue being a live issue, but it really comes back to making sure that as franchisor, you are being realistic in the expectations you put on franchisees about how much profit they can make and what their costs are going to be in order to operate the business.
Interesting, very interesting.
Thank you.
Verónica, ¿tenemos alguna otra pregunta?
No, no hay preguntas en el chat.
Vale. Okay, so we don't have more questions for the moment for you guys. So thank you very much. I think only to say, I believe that to give to say who are our upcoming, what are our upcoming webinars, which are Italy, France, and Morocco on the 27th of October, and India and Middle East on the 11th of November. And we trust you will be with us again.
Thank you for having us.
Thank you.
Thank you.
Thank you.
Bye.
Bye-bye.
Bye-bye.
Bye.